You're live.
Good afternoon. Welcome back to the House Judiciary Committee. It's Thursday, the 3rd of February. We have two bills here hearing today. This is bill hearings today. The bills will both be 3 minutes for the sponsor, both of which is Delegate Crutchfield, and 2 minutes for the witnesses. So it'll be relatively straightforward. And why don't we get started? So we'll start with House Bill 284. Again, both bills from Delegate Crutchfield. There are 4 witnesses, including Delegate Crutchfield. So Delegate Crutchfield, Brett Engler, Debbie Feinstein, Catherine Marsh. Go ahead, Delegate Crutchfield.
All right. So good afternoon, Chair Clippinger, and I think Vice Chair Moon is on, as well as all my colleagues on the Judiciary Committee. For the record, I'm Delegate Charlotte Crutchfield, and I represent District 19 in Montgomery County. And I am here to provide testimony in support of House Bill 284. House Bill 284 will expand the hearsay exception for victims set forth in Section 11-304 of the Criminal Procedure Article. Current law allows prosecutors to admit statements made by children under the age of 13 that relate to child physical and sexual abuse, when those statements are made to certain people, including doctors, social workers, teachers, and therapists. The proposed law would extend the exception to child victims of neglect and crimes of violence. Lastly, the proposed law will extend the exception to child witnesses to crimes of violence. The reasons that justify the current hearsay exceptions also apply to statements made by child victims of neglect and child victims of and witnesses to crimes of violence. A victim's or witness memory of an event is much stronger, closer in time to the precipitating event, which is when most of these types of statements are made. Additionally, cases of this nature often involve complex family dynamics that may, over time, result in a child becoming reluctant to speak about the abuse they experienced or witnessed, minimizing the nature of the abuse, or even recanting their allegations altogether. A child's out-of-court statement made close in time to the event in a safe, comfortable environment out of the presence of the perpetrator and before being subjected to the pressures of their family members is trustworthy and reliable evidence. Expanding this hearsay exception to include child victims and witnesses to certain crimes will allow a judge or jury to hear a full and true account of what happened to a victim or what a witness saw. For these reasons, I urge a favorable report on House Bill 284. And just want to add, there are amendments, and they're all technical, just to clarify that this bill includes victims and witnesses as well. And so I'll turn it over to the panel.
All right, we will go to Brett Engler, please.
Hello, members of the committee. Thank you for allowing me to address you this afternoon. My name is Brett Engler. I'm the Chief of Domestic Violence in Frederick County State's Attorney's Office. We know that 1 in 15 American children are exposed to domestic violence each year in their homes. We know that child abuse and DV often co-occur. Even if the child is never actually harmed, the trauma from witnessing the abuse of a mother or a loved one can affect them for the rest of their lives. We have CACs, child advocacy centers here in Frederick and all across the state that are set up to provide trauma-informed, scientifically reliable interview techniques meant to obtain accurate information from child witnesses. Passing this legislation will allow children to tell the details of what they witnessed in a calm, trauma-informed environment. It'll assist the state in proving cases without putting the child on the stand without a forensic interview, which was done closer in time to the time of the crime. And the interviews will assist the jury in determining what happened and finding the truth in these situations. The legislature several years ago passed crime of violence in the presence of a minor, recognizing for the first time that children who witness domestic violence or violence at all, murder, stabbing, strangulations, all cases that I have had, really takes a toll on them. So this will only be an extension of that truth, and I urge a favorable report. Thank you.
All right. Debbie Feinstein.
Good afternoon, Chairman Clippinger and members of the Judiciary Committee. Thank you so much for hearing us this afternoon on this important bill to advocate to expand the hearsay exception for young victims of violent crimes as well as child neglect. As you have heard, 11304 currently extends to children that are victims of child abuse and other sexual offenses. I want to make something super clear, and I'm sure this has already been made. I apologize, I was having trouble logging in. I didn't hear the first few remarks, but I want to make something super clear because this was a concern last year. One of the concerns about this bill relates to the fact that is the defendant going to have the opportunity, as is their right under the Constitution, to confront the victim about the crimes that the child is alleging against him, her, or them? The full answer is absolutely 100% yes. The confrontation clause is protected. It's protected in the current 11304 statute, and it remains protected in the legislation that is proposed today. The child must testify before the state even has the opportunity to introduce the statement that is made to the statement taker. I would lastly like to note that I can't tell you the number of cases where I have had to, escort a small child under the age of 13 up to the witness stand to testify in a case involving child abuse. There have also been cases where children are witnesses to other cases. In the cases involving child abuse, where we have an 11304 statement, the child has to be subject to cross-examination. The child has to speak. That it is an incredibly terrifying experience for them to have to testify, typically in front of the person that committed this atrocious, horrible crime, either, against them. And right now we have, again, in child abuse cases, we have the opportunity to introduce their prior statements. We do not in the other types of cases that the bill, the proposed legislation would extend to. And I would urge your support of this important bill this morning. Thank you so much, or this afternoon. Thank you so much for your consideration.
Thank you very much. We'll go down to Catherine Marsh, please, for 2 minutes.
Good afternoon, Mr. Chair, members of the committee. My name is Catherine Marsh. I'm the Special Victims Liaison for the Charles County State's Attorney's Office. Criminal Procedure 11304 allows for the admission of a very limited amount of out-of-court statements made by children 12 or under after the court goes through a detailed analysis outlined by the statute to determine that there are guarantees of trustworthiness. It does require that the child testify. 11304 recognizes the trauma that children suffer. There's a wealth of research on adverse childhood experiences and trauma-informed forensic interviews. Neglect and witnessing violent crimes like homicide and rape are adverse childhood experiences. This year, I worked with an 8-year-old girl who was asleep in her bed when she was awoken to her second-floor bedroom window being broken by her mother's ex-boyfriend climbing through. He assaulted the child and threatened further harm to her and her family if she contacted anyone. He then went into her mother's room where he strangled and raped her. The 8-year-old girl had a full forensic interview completed by a certified forensic interviewer. These interviews are developmentally sensitive and legally sound, having been upheld under the Daubert standard. This 8-year-old girl's statements about the assault the defendant committed against her would have potentially been admissible under 11304 had he still been dating her mom and living in the home. However, as he no longer lived in the home, it was not. And her out-of-court statements about what the child witnessed happening to her mom are never admissible under current 11304. I think we can all agree that the trauma this child suffered was the same whether the defendant was a household member or not. These extremely limited out-of-court statements have been upheld time and time again in our courts. However, the statute was originally passed prior to the legislature passing criminal neglect of a minor, committing a crime of violence in the presence of a minor, or sex trafficking of a minor. This legislative body has recognized the criminality of these additional actions and the trauma the children suffer. I request a favorable report on this bill to expand 11304 to also recognize that trauma. Thank you.
Are there any questions for the panel? Seeing none, that concludes the testimony on House Bill 284. There's no one signed up in opposition. We thank you all very much.
I'm so sorry to interrupt. I believe that Sarah Kulo was also signed up to testify on this bill. Is that on there? She's, I think, in the waiting room for the Zoom. I apologize. She's a forensic interviewer that was going to provide information about this bill.
I do not have her listed.
Okay. All right. Thank you so much. I apologize for the interruption.
That's all right. But now we have a question. So now you all can't leave. And we'll go to Delegate McComas.
Thank you. I just wish, I guess it's Miss Marsh. You were talking very fast. I appreciate that. But you indicated that some of the bills that we passed were more forward thinking than what we're trying to change now. And I just wondered what the time frame was, because I missed it. You were talking too doggone fast for me.
I apologize. I was trying to adhere to my 2 minutes. So when 11304 was first passed by the legislative body to admit these out-of-court statements, this happened actually back, I think, in the early 90s, either very late 80s or 1990s. I mean, the first court case I have upholding it was 1990. So it had to have been a little bit before that. Since that time, it's been amended a little bit after the Crawford opinion by the Supreme Court to ensure that the child must testify. But Maryland itself hasn't expanded what crimes under 11304 since that time. And since 11304 was first passed by the legislative body, it is now a crime to commit criminal neglect of a minor. It is now a crime to commit crime of violence in the presence of a minor or sex trafficking of a minor. None of those were crimes in Maryland when 11304 was originally passed.
Thank you. If you recall, do you recall like when some of these were passed?
So criminal neglect of a minor was 2015 or 16. I think committing crime of violence in the presence of a minor was 2016 or 17. Those have been relatively soon, and sex trafficking of a minor became the felony just a couple of years ago.
Okay. Thank you very, very much.
Delegate Cardin.
Thank you, Mr. Chair. I'm wondering, Delegate Crutchfield, if you still happen to have a forensic interviewer in the waiting room, might she be able to explain to us why we should expand this to any crimes concerning neglect of a minor or crimes where the victim or the witness in the case it was in a crime of violence? If you happen to have a forensic interviewer there, I'd love to hear her perspective for maybe a minute.
Well, it appears that Assistant State's Attorney Feinstein would like to make some comments on that for you.
So I was just corresponding with Ms. Hulo-Malave, who is scheduled to testify to exactly the perspective of a forensic interviewer. She said that she signed up. I'm not sure what the disconnect was. I'm not sure if there would be an opportunity for her to present her testimony. She also submitted written testimony.
If you can get her information to me, maybe I can talk to her.
If staff still sees her in the waiting room, I'm counting this against Delegate Cardin, and
that would be great. I also want to point you
not going to do this all the time, everybody. We try.
Thank you.
Try.
I also want to point you to there's written testimony that was submitted by several other individuals who are associated with child advocacy centers, a director of one, a forensic interviewer, and another, actually a forensic interviewer who actually outlines the scientific studies and background relating to forensic interviewing. So that's all in the written testimony that was submitted. They were not available to testify in person today. And thank you for the opportunity, Chairman, to have Ms. Kulo testify.
I'm becoming a softie. Delegate Arakan, I can read lips, and I saw that you just said you were always a softie. That's fine. Ms. Kulo, you have been added to the list. You can speak for 2 minutes, and I'm looking forward to Delegate Cardin's thoughtful and insightful questions to you. Ms. Kulo, please go ahead.
Oh, thank you so much. Good afternoon, members of the Judicial Proceedings Committee. My name is Sarah Kulo-Malave, and I was the dedicated forensic interviewer for the Treehouse Child Advocacy Center of Montgomery County for the past 8 years. And forensic interviewers are required to receive extensive specialized training in one or more nationally accredited forensic interview protocols. These protocols are researched and evidence-based. They are specifically designed to elicit reliable information from a child about an event or events they may have experienced and or witnessed. Although referred to by different names, each protocol follows the same basic semi-structured process. They all use developmentally sensitive language and focus on using open-ended, non-leading questions. Studies have shown that open-ended questions elicit more narrative responses, reduce suggestibility and inaccuracies in recall. Although all interview protocols include instructions for the alleged victim or interviewee. For example, one rule is that we only talk about events that actually happened or are true. Another rule is that the alleged victim or witness must correct the interviewer if he, she, or they get information wrong. This is another technique used to reduce suggestibility and or false information. Finally, the forensic interview training dictates exploring alternative hypotheses to the allegations, and therefore the forensic interviewer is considered a neutral party. In my role at the Treehouse, I interviewed child witnesses to domestic violence and homicides. For example, I interviewed a 13-year-old developmentally delayed child who was at home when his father was murdered. And I also interviewed his 9-year-old sister who arrived home from school to find her father laying in a pool of blood. These events are incredibly traumatic in and of themselves. An expansion to the current hearsay rule would allow the reliable statements that they made to me in a safe environment and not in the presence of their father into evidence. And therefore, I urge support of this bill. Thank you.
Thank you very much. I guess Delegate McComas now has a question. So I was looking for Delegate Cardin to give him further grief, but we'll go to Delegate McComas instead.
Well, I appreciate Delegate Cardin's chivalry in this issue, and I hope that he's not blacklisted because of it. He did a good job. Anyway, I wanted to know if these interviews, the forensic interviews, are recorded, so that, in other words, the defense can look at it and see that everything's above board. Are they recorded? Video
Yes.
as well as audio?
Yes, both.
Now,
Yes.
is it possible, I'm just wondering is it possible that we could see one that would be appropriate or disguise the child's name and face, just kind of so we could see how it's done, a recording or something? Because I think that would probably help get this over the goal line, definitely.
I mean, that's something I would have to discuss.
No, I understand there's
yeah.
privacy and obviously
Yeah.
it would have to be a case that's not currently pending and everything. But if,
Right.
you know, hide the child's face and information, but just so we could kind of see that there's a lot of protections in the process, that would be very helpful.
Oh, absolutely. Yes.
Okay.
And if I may answer part of your question, the state is required under the statute to file a motion in advance, at least 20 days before, that we intend to use the hearing or use the statement. The video recorded statement must be provided to the defense. They have the right, the defense, to do a deposition of the interviewer prior to the hearing. The court then does a hearing outside of the jury's presence to determine if the statement has a guarantee of trustworthiness before the court even determines that the state would be permitted to play it. And I believe it's 13 different factors that the court must analyze in determining guarantees of trustworthiness before it's even on the table for the statement to come in. And 11304 currently does outline all 13 of those factors, but one of them does include, is there a motive to fabricate? So for example, if there is a child custody hearing, the defense will bring that up as one of the factors for their court to consider, but the statute does outline all 13.
One other quick follow-up, Mr. Chair, if I may. How many other states have statutes that comport with what's being proposed today, if you know?
I don't know off the top of my head. I can find that answer and email it to Delegate Crutchfield. What I can say is every single state, it is a national standard to have forensic interviews, and a Center for Children and under the National Standard for the Children's Alliance.
Thank you very much. Thank you, Mr. Chair, for being.
Now for the greatest question ever asked. Delegate Cardin.
Thank you, Mr. Chairman. Ms. Kulo, just based on your very well done testimony, it is appropriate then to have these forensic interviews expanded to issues concerning neglect and all crimes of violence, which presently Maryland doesn't do. It only does it for those specific enumerated crimes, right?
Correct, yes.
Okay. And you guys think, your expert opinion, that it's good to expand it to these because, and this is comprehensive now. Once we do this, there's not going to be other ones that we're going to come back and do, at least not at this time. Is that fair to say?
I think Ms. Feinstein's, I would say yes, but I'll defer to Ms. Feinstein.
So may I speak to that? Is that okay, Chairman Clippinger? I know we often don't like two people responding to the same question. Okay, thank you.
That's fine.
Our intent was to have it be comprehensive, but as Ms. Marsh described, the law sometimes expands, new laws are passed. So there certainly may be reasons that we would want to bring additional legislation forward, but we thought long and hard about this legislation. It's been introduced in different forms before this committee before. We really tried to hone in on the most important cases, the most serious cases, and to allow children who are similarly situated to child abuse and sex offense victims to be able to essentially have this tool be a part of their case and to give them the same access to justice as other children. So we really were very careful about what we included. The definition of crimes of violence is the definition under 14101 of the criminal law article, which only includes the most serious crimes. It doesn't include misdemeanors. So really, again, it is a very targeted, focused bill so that we can really have this utilized in cases involving homicide, kidnapping, a child that witnesses a rape, a victim of child sex trafficking. None of those individuals are currently included in the law as it stands. And if I may go back, I don't know if there's a follow-up question, but if I can go back also to the request that Delegate McComas made about viewing a forensic interview. Is that okay if I do that? Thank you. I think we can try. I mean, we can try to find a case where there was, where that testimony was introduced in court, because then it would be an exhibit. Although oftentimes they're sealed as a part of the record so that the public can't access them. So I'm not sure that we're going to be able to do that, but I know for sure that Ms. Kulo there's another woman from Baltimore City, another woman from Frederick, who are all forensic interviewers. They could talk you through the process and the training. There's a rigorous training in Maryland that forensic interviewers have to undergo before they can even begin to conduct these interviews. Our Child Advocacy Center also peer reviews the work of the forensic interviewers to make sure that it comports with the standards. And I think the critically important part of the forensic interview, from my perspective and from sort of the perspective of a prosecutor, our goal is to get at the truth. And a forensic interview asks the questions in such a way that are non-leading, non-suggestive, with the goal of getting to the truth, giving the child multiple opportunities to change what they're saying, and to say if there's any reason that they're giving these statements, or if anyone is forcing them to give certain statements. And that really is what enhances the reliability. And that's why 11304 has been on the books for so long and has withstood the test of time, really, and the test of the appellate courts. So we will do our best, Delegate McComas, but we certainly stand ready to have additional conversations. And I'm happy to set that up for you with the forensic interviewers and for any other of you on the committee that would like to do that.
All right. Seeing no further questions, now we're done with the testimony of House Bill 284. We thank everybody very much. And there's no one signed up in opposition. Now we're going to House Bill 296. And there are 3 people favorable with amendments, so we're going to keep them separate. There are 8 favorable, and one of them is Delegate Crutchfield. How are we going to do this? Right over the line. Let's just hear from Delegate Crutchfield for 3 minutes, then Robin Belsky, Melanie Shapiro, and Amanda Rodriguez, and then we'll do the remainder of the favorable, the next as a favorable panel. So Delegate Crutchfield, you have 3 minutes. Go right ahead.
All right. Once again, thank you, colleagues. For the record, I'm Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County, and I'm here to testify in support of House Bill 296. This legislation will enable a petitioner who is eligible for protective order while seeking care at a hospital with the ability to electronically file a petition for an interim protective order with a district court commissioner. House Bill 296 is about improving access to our courts for some of Maryland's most vulnerable. This bill applies to everyone eligible for a protective order: children who have been abused, vulnerable adults who have been abused, victims of assaults, and victims of domestic violence. If someone is in the hospital setting, then they can petition for a protective order with this bill. We recognize our hospitals are experiencing extreme staffing shortages, and those that work in hospitals have worked harder than ever throughout the pandemic. That is why the bill enables hospitals to assist with filing a petition and does not require them to do so. But our hospitals play a critical role in identifying victims. Health practitioners are mandated reporters of child abuse and abuse of vulnerable adults. Forensic exams for victims of sexual assault are conducted in hospitals, and screenings for domestic violence are conducted in our hospitals, and some even have domestic violence programs in the hospitals. With all of the technology that we have come to rely on in the past 2 years, we would really expect someone to leave a hospital, navigate their way to a court, and then file a petition when they can do so right there in the hospital. Even before the pandemic, bail reviews were regularly conducted using video conferencing. And in my own county of Montgomery County, the Family Justice Center has facilitated petitioning for protective orders, and petitioners participate in hearings with the Family Justice Center using video conferencing with the courts. I have met with the judiciary and do not believe that any of their concerns are insurmountable. To address a few of them, first, there have been 2 amendments to the bill. Urgent care centers have been removed from the bill. Second, the court raises concerns regarding the ability to access a victim's credibility. The court has been conducting countless hearings over video conferencing for the past 2 years, including some temporary and final protective order hearings, and have been able to assess the credibility of witnesses in those proceedings. Maryland's rules already address electronic participation in civil district court proceedings, and the burden of proof for interim and temporary protective orders is reasonable grounds to believe. This bill is intentionally limited to interim and temporary orders of protection and does not extend to final orders of protection, which are longer in duration and have adversarial proceedings. Third, the court raises privacy concerns from a hospital. Is a court setting actually a more private setting than a hospital? Are protective orders conducted in closed court proceedings? And I encourage you to read the written testimony, some of which outlines how dangerous it can be for a victim to go to a courthouse or a commissioner with abusers waiting there to threaten and intimidate and prevent someone from going through the protective order process. Let's empower petitioners with the protection of a protective order before they walk out of the hospital door. I respectfully request a favorable report for House Bill 296.
Thank you very much. We'll go now for 2 minutes to Robin Belsky, then Melanie Shapiro and Amanda Rodriguez. So Robin Belsky, please, for 2 minutes.
Mr. Chairman and members of the committee, my name is Robin Belsky, and I am the chair of the Advocacy Committee of the Board of HANA, a program of the Associated Jewish Federation of Baltimore. I am testifying in favor of House Bill 296. HANA is a domestic violence, sexual abuse, and elder abuse agency that serves the citizens of Baltimore County and City. HANA provides safety planning, emotional counseling, sheltering, and legal advocacy. We follow up on all domestic calls from the Northwest Precinct of the Baltimore City Police Department. We receive referrals from hospitals and healthcare programs around the area, especially in the field of elder abuse. HANA regularly speaks to clients about the benefits of the protective order process. While many are interested, for some, The physical barriers of going to court and testifying before a judge are medically insurmountable. Hannah served a client who was attacked by her boyfriend after he broke into her apartment. The only way she could escape him was by jumping out of her third-story apartment window. She sustained very serious injuries from him in the fall. She was in the hospital and rehab for weeks. While her abuser was thankfully arrested, he began writing to her from jail almost immediately. Hannah's staff discussed a protective order with her on many occasions to stop her abuser from contacting her and to protect her in the event that he was released. Ultimately, she decided that she was physically unable to get to the court to file. If this bill were in place, she could have gotten the protection she needed, the communication from her abuser could have stopped, and she could have focused on her healing. Hannah also served an older adult who was assaulted by her nephew, who she raised. While hospitalized from her injuries, Hannah advocates discussed the benefits of a protective order with her so that her nephew would have to vacate her apartment and she would have a safe home to return to once she was released.
Ms. Belsky?
She agreed that she wanted the order, but could not go to court physically. We ask you to support this bill so that our clients can receive the full relief and protection that they truly need when they have been abused and are medically unable to attend court.
Thank you.
Thank you.
Thank you very much. Melanie Shapiro now, please, for 2 minutes.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence. When the pandemic hit, we all switched to platforms such as Skype, Zoom, and WebEx to perform our jobs. Court buildings closed and proceedings went online, but even before the pandemic, courts in Maryland conducted remote proceedings such as bail reviews. Rules already existed regarding the use of video conferencing in certain criminal and civil court matters. Also during the pandemic, both child abuse cases and domestic violence cases got more severe. We had the examples of New York, New Jersey, North Carolina, West Virginia, Indiana, California, Minnesota, and Washington, D.C., just to name a few of the states that have improved access to the courts and safety for victims of abuse by implementing a process that allows a petition to be filed electronically and hearings to be held virtually. Each process looks a little different. In some states, anyone can petition electronically, and in other states, it must be done by a program or an advocate. HB 296 would allow anyone eligible for protective order to file an interim or temporary protective order petition electronically from a hospital and have the interim and temporary hearings heard virtually. It is intentionally limited to what are already ex parte hearings and does not extend to the final protective order hearing. The bill is also enabling to hospitals and not a requirement. For example, some hospitals, approximately 12, have hospital-based domestic violence programs, but not every hospital is so fortunate. Hospitals are a critical point of identification and intervention for victims of abuse, including child abuse, vulnerable adult abuse, as well as sexual assault and domestic violence. The emergency department is often the first point of care for victims of intimate partner violence experiencing acute injuries. Up to 14% of female patients treated in the ED are there for IPV or intimate partner violence related conditions. In addition, between 5% and 38% of all women seen in the emergency department reported experiencing IPV in the previous year. Emergency room visits are also an indicator of lethality risk. We must prioritize the safety of victims and improve access to courts. There are numerous barriers to accessing courts, including an abuser that may be stalking a victim and tracks them to a courthouse, someone unable to leave the hospital bed to get to the courts, and the abuser in the waiting room ready to offer a ride home. There is also the very real barrier of transportation, which you can read about in the written testimony. We must do better. We have the technology, the rules exist. We must remove the unnecessary barriers constructed and allow victims better court access. Urge a favorable report on House Bill 296.
Thank you very much. Amanda Rodriguez, please, for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Amanda Rodriguez. I am the Executive Director of Turnaround, which is the Rape Crisis Center for Baltimore County and City. I'm also speaking on behalf of the Maryland Human Trafficking Task Force. As a Rape Crisis Center, we partner with both of our local SAFE programs within hospitals, both here in the city at Mercy and then also at GBMC in Baltimore County. So work regularly with them in terms of making sure that victims have access to care. When COVID hit, we all went virtual, including at a rape crisis center. We currently can provide completely virtual services to every survivor that needs access to them. And we saw a 300% increase in need during the pandemic, and it has not gone down as a result of the increased violence that we're seeing in our communities. Those protective orders are vital and a very integral part in making sure that a survivor has a safe place to go. There are two specific stories that I'll highlight super quickly just to highlight that point. So one, we had a client who was a domestic violence survivor. She actually was beaten so badly that her jaw was broken. There were multiple broken bones. She sat in the hospital for several weeks, and then upon leaving had to go into our safe house. And when she did so, she was not physically able to get to the courthouse. She wanted a protective order but did not have access, and ultimately had to go back to her abuser because she did not have access to that immediate protective order care, and he was reaching out constantly during this time. The other is, as a rape crisis center that is short-staffed at all times, I've answered the helpline. There was one Friday evening where I answered the helpline. There was a human trafficking survivor on the phone who was in the hospital here in Baltimore. I spoke to her for about 4 hours, and ultimately she decided that she wanted to get out. However, this was Friday night. By Sunday, the abuser, the trafficker, had come to the hospital and actually took her from the hospital back into a trafficking situation, and we lost access. There was actually fear that she had died afterwards because we were unable to gain access, and there was a police report that matched her description. So we would ask for a favorable report for this bill. We believe that it is an important part of keeping victims safe.
All right, thank you all very much. We'll take questions now, and I see Delegate Anderson, who is not in fact in the committee room, has a question. Delegate Anderson.
Thank you for outing me, Mr. Chairman. I appreciate that. I agree with this bill 100%, and my only concern is how do we get the other end of it done electronically? For instance, currently, as you mentioned, with bail reviews, there's already a very sophisticated and elaborate system set up in all the district courts where the judge has access to a video screen. A camera is on him. He can see the defendant in the room where the interviews are being occurring. There's a camera there. So, and all of that's done obviously with state expense. You can also do bail hearings with at least an audio virtual situation. I did one last night, in fact, with the commissioner in Baltimore County. So my question, though, is that, yeah, the judges are going to have access to this equipment and the ability to do it. How does the victim get access to that same system, especially if it's a person who may have been homeless or someone who doesn't have, a laptop or a smartphone with a camera, things like that? Is that part of the bill, or just can you just go on a little bit about how that would happen?
Yeah, if you don't mind, I'm going to let Ms. Shapiro answer that question.
Okay.
Thank you so much for that question, Delegate Anderson. So there are a lot of different platforms. Let's start with what other states have done. So there's something called Law Help Interactive. There's Odyssey Guide and File, Adobe Smart Forms, this A2J Author. These all different things that have been utilized by different states. So some of this is in conversation. Hopefully, once this bill passes, and working with the judiciary to implement that. One state actually has these kiosks that are located in different jurisdictions, and they submit it through that, and then they get a phone call. So our rules already allow for the video conferencing. And one of the reasons why this bill is not as expansive as other states that allow for anybody to petition from anywhere is to ensure that they have the access to technology. So hospitals have these resources. They, can use the domestic violence programs. There's about 12 around the state that could assist. And so somebody just really needs a phone or a tablet. I believe that telephonic participation is actually permitted through the rules in district court proceedings. And so that piece of it, and electronic petitioning does not necessarily mean MDEC. It can mean email, it can be fax. When we worked on the drafting of it, we were told that it includes all those different things. It's not limited to MDEC. So,
Ms. Shapiro, I guess another question is that I know with a bail hearing, many judges want to actually see the face of the defendant before he assesses whether or not the defendant's going to be released or held without bail or with a money bail. Do you think that judges ought to, or do, well, I don't know, ought to, but would judges want to see the face of the individual who's making the complaint and filing the petition to try to assess just whether or not the judge should grant it. Should these be video hearings?
I'm not going to say whether or not it should or shouldn't, but I don't think that having it be a video hearing would be a burden that can't be met, because all that needs to happen. I mean, when I was doing virtual court proceedings with clients I was never in the courthouse, and we would all get links. I would make sure my client would go on and they would click on the Zoom link that was sent, and they would appear, and they would do it from their home. And I would be sitting in my home and clicking on the link and doing it from there, just like we're all sitting here testifying and discussing this legislation, all from various locations around the state. And so all that needs to happen is the Zoom link needs to be created and sent.
Yeah, I just want to make sure that many of the folks that probably would use this the most, people who are, not well-to-do, might be homeless or whatever, have the same access that the rest of us have, and that judges would be not hamstrung by not being able to see the face or be able to assess the applicant during the hearing.
Exactly. And that's why we had it connected to another place, so that, hospitals are sort of this critical point of contact, and they can help facilitate the sort of the hearing process. If it's getting an iPad or having somebody, a phone, something like that a person might not even have. If they've been a victim of violence and come in through the emergency department, they might have nothing but what they were wearing.
Okay. All right. Thank you so much.
And Delegate Anderson, remember, this is to the commissioners, right? This is for interim and or temporary. So the commissioner would be the one to make determinations as to what happens next with the petitioner. Okay.
A court commissioner?
Yes, a court commissioner.
For a
interim protective order.
Interim protective order. Okay.
Yes, correct.
But still, we want the video I would like to see it to be video, because I think, whoever the judicial officer is, probably in a situation like this, when you're going to, impose certain sanctions, it might include custody of a child or whatever, that the judicial officer has a chance to see the person. And if that person doesn't have the same kind of access that most of us have, they may not be able to take part in it. So whatever we do, I'll help you, or just let me know.
Thank you. Appreciate it.
Okay.
Delegate Cardin, then Delegate McComas. Delegate Cardin.
Thank you, Mr. Chairman. And thank you again, Delegate Crutchfield, for these great pieces of legislation. Let me just, and I think this is probably going to go to either Ms. Rodriguez or Ms. Shapiro or Ms. Belsky. But are we going to have an issue where lawyers are advising clients to then go to hospitals to start filing petitions? I mean, in the legislation specifically says you have to be receiving medical treatment at a hospital, and I guess you took out urgent care centers. It's still in our text in your amendment, but I would worry that we would be setting up sort of virtual. We may have an unintended consequence where people who are not necessarily the specific individuals we're looking to help here, which I completely understand and agree with Delegate Anderson on, that we need to figure out a way to do it. We could have I could say to a client who is dealing with a totally non-domestic violence related issue, just go over to the Sinai Hospital and file it there, because you can. And I would be concerned that we're opening up a can of worms. And is there any safeguards in the legislation to make sure that doesn't happen?
So thank you for the question, Delegate Cardin. I need to look carefully to ensure, it's not intended. Now, to be clear, there are some states that have done that. They've in fact designated other locations outside of the courthouse, recognizing that they're more easily accessible for victims of violence to get to. Like I mentioned, those kiosks, and a lot of other states have done it by way of programs or advocates. New Jersey actually was one of the first states to do this over 10 years ago, and they had hospitals as the starting point. And so I have to see if there's actual language in there that says receiving care, but I don't
Right.
particular
It
the
says
issue?
receiving medical treatment at a hospital or urgent care center may file electronically the petition.
Right.
And the question is, I'm assuming you would have to show that you are at somehow or sign some sort of affidavit saying that you are receiving care. So let's just say that I have, this is for a protective order. There's not necessarily an urgency where somebody is in need of medical treatment, but yet it's more convenient for them to go to the hospital to do it. Is that something that you guys are intending on having happen so that we are creating more, maybe it is, but we have to know that that's what we're doing, because the hospitals, I'm assuming, are going to be testifying at some point, are going to need to be aware that there could be an increase in traffic for that reason if people are coming there just to be able to file.
Thank you, Delegate Carton, because I think you've raised some really good points and questions. I do think that's something where we need to look into.
Delegate McComas.
Thank you, Mr. Chair. I don't know. Every time I've gone to the hospital for an emergency thing, you got to check in, you got to wait, they got to call you, you got to have your insurance card, you have to have probably your driver's license. You can be sitting there for a heck of a long time. So I personally don't think this is going to be abused. I think anybody that goes to a hospital, they're not going to just let you roll in and say, oh, I have a sliver in my pinky. Oh, and by the way, I want to file a protective order. I just don't think that's going to work that way. I just don't see it, because there's so many, you have to go through so many gatekeepers to even get in to see a doctor. And I'm sure that you're not going to go in to get a protective order that way. There's got to have been some serious injury before you go to the hospital. So I don't see it as an issue. Now I could see where the hospital might not want to have to provide that, but I think it's a very good idea when someone has had to seek medical treatment. So I think the bill has some very, very worthy goals.
Thank you, Delegate McComas. And you're right. When you go into the hospital now in particular, they do ask questions regarding, abuse, et cetera. So there are a lot of, as you mentioned, guardrails, before care is even given to you.
All right. Seeing no further questions for this panel, we thank you all very, very much. And now we're going to go to the next panel of favorable witnesses, who include Michelle Smith, Vicky Sneed, Sarah Meeke, and she's a constituent, and I never get the last name right, Jessica Emerson as well. So that's Michelle Smith, Vicky Sneed, Sarah Meeke, and Jessica Emerson. We'll go with Michelle Smith to start, if she is here. There she is.
Hello.
Hello, Michelle Smith, for 2 minutes, please.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee, and Delegate Crutchfield. Thank you for this excellent legislation. I am Michelle Smith. I'm testifying today on behalf of the Family and Juvenile Law section of the Maryland State Bar Association. We urge a favorable report of House Bill 296 to better provide access to the court protection for our family law clients who are victims of interpersonal violence. The aftermath of interpersonal violence is the most dangerous time for many victims, and it will be an obvious advantage for them to be able to apply for interim and temporary protective orders from the safety and supportive environment of the hospital. Removing barriers for those who are physically unable to get to the court for days, weeks, or sometimes months to apply for and obtain court protection is a laudable outcome of this bill. The injuries perpetrated by the abusers should no longer be a physical barrier to protection. I'd like to also say that I was listening to those who previously testified and some of the questions that were posed. And I would also indicate that the Family and Juvenile Section Council does support the amendments, which are not reflected on our paper copies, but which have been testified about, as well as the concept that, sure, it's going to be a little tricky to get this instituted. I have been on the other side of the bail reviews that have been testified about when those were newly implemented, and there were bumps in the road, but I feel like it is not insurmountable. I would agree with that, and we would support a favorable report for House Bill 296.
All right. Now we will go to Vicki Sneed, please. Vicki Sneed. All right. Now, Sarah, I can never remember how to pronounce your last name, and I've heard it a million times, and I apologize.
It's Mickey, like the mouse.
That's right. Well, here's 2 minutes then.
Good afternoon, Chair Clipman, members of the committee. I'm Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies, including HANA, our domestic violence, elder abuse, and trauma agency. HB 296 comes from conversations with staff from HANA regarding issues, like you heard, of clients leaving the safety of a hospital without any protection from their abusers. So if a victim is in the ER in Maryland and is screened as they're supposed to be for violence, discloses the violence, what can a hospital do now? While some hospitals may connect them to a program or may have a program in the hospital, a social worker or a forensic nurse, they cannot ensure the safety of a victim when they leave the hospital. In fact, their abuser could be in the waiting room pre-COVID or in the car. Further, as you know, violence is not ever only physical. It can be emotional, financial, and technological. Many domestic violence victims are electronically tracked by their partners, making it very dangerous to dive to a court or commissioner's office, but a hospital can be a safe place. This bill is simply about expanded access to safety and justice for violence victims. I connected with Melanie at the Maryland Network Against Domestic Violence, and we began researching different states to see if they had any solutions. Like you heard, New Jersey has had a hospital program for over 10 years, where victims can file and have protective orders in the hearings in the hospital. Several states were considering similar and even more expansive legislation and pilot programs over the summer, and many, like Washington State and California, now have passed laws allowing for similar electronic filings and hearings. This bill only allows for interim and temporary orders, which are both ex parte hearings, to be virtual. The final protective order hearing would still have to be in person. Maryland courts have been for almost 2 years conducting both civil and criminal proceedings virtually. We have the technology. Now let's use this technology for good and use the positive we've learned from COVID to help victims of violence have more access to safety. For these reasons, we ask for a favorable report on HB 296, and I'm happy to answer any questions.
All right, that's fine. We were looking for Jessica Emerson and Vicki Sneed. Neither one are here.
Jess had to leave, but she has her written comments. Yeah.
All right, that's fine. And we don't see Vicki. So are there questions for these two witnesses? All right, seeing none, we thank you for your testimony very much. And now we'll hear from 3 people who are favorable with amendments on the bill: Dorothy Lennick, Lisa Jordan, Laurie Ruth. We'll hear from the 3 of them for 2 minutes each. Let them come in. I see Dorothy Lennick, see Lisa Jordan. Dorothy Lennick. Excellent.
Good afternoon, Mr. Chairman, members of the committee. My name is Dorothy Lennick. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. House of Ruth serves victims of domestic violence throughout the state of Maryland. The House of Ruth 100% supports the idea that a victim who's in the hospital as a result of domestic violence ought to be able to file for a protective order electronically. We have 2 concerns. The first one is I can't figure out how they're going to do the interim protective orders through the court commissioners electronically. Despite when anybody else has told you all the interim protective orders were done in person during COVID, because there is no way to electronically reach the court commissioners. Anything that's done in the court is set up by a court clerk or staff of the courthouse, so the judge knows the case is happening and the person in the petitioner knows it's happening. But the way that a protective order starts, the difference with protective orders is somebody walks into the courthouse or walks into the commissioner's office and says, here I am and I want this order. And there's no electronic way to make that happen right now. A system I think could be created, but there's no way with the commissioners right now. So one of the suggestions I had is, why don't we start with just doing the temporaries, and then somebody could call to the clerk's office and say, we have a petitioner here who wants to apply for a protective order. Let us know when you have a judge available. So it's really just a technological issue is my first concern. My second concern really is that it's very important for a survivor of domestic violence to be connected with a domestic violence service provider. We represent hundreds of people in protective orders each year at the House of Ruth. And while people can do it on their own, it's so much better when they connect with the House of Ruth and all the other domestic violence programs in the state, not only because we can represent them, but because we can do a lethality assessment with them, we can help them create a safety plan, we can link them to other services. So we want to make sure that if and when the system gets set up, and I think it will get set up, it's definitely the way to go, but that we make sure that we get those survivors linked to domestic violence, sexual assault programs, so they have access to all the services. We cannot expect the hospital-based programs, yes, but not all hospitals have hospital-based programs. We can't expect the staff at night. My daughter works overnights in a hospital, so I can tell you from her experience.
Ms. Lennox.
I will finish up. They just won't have the ability to provide all those services. So for those reasons, I urge you to amend this and report favorably. Thank you.
Thank you very much. Lisa Jordan, please, for 2 minutes.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We urge the Judiciary Committee to report favorably on House Bill 296, but really simply with a sponsor amendment. So it's not a serious substantive amendment. We wanted to convey that this really fits well in Maryland's hospital response to sexual assault survivors. You've already heard from my colleague, Ms. Rodriguez, about the perspective of a rape crisis center, but know that there are 24 sexual assault forensic exam programs around the state with specially trained nurses and also advocates who assist sexual assault survivors in the hospitals. So you do have that advocacy support that Ms. Lennox was referencing. We also would respectfully suggest to Delegate Cardin that it's a good idea to encourage survivors to seek health care. So if it is an unintended consequence to drive survivors to hospitals, that's not a bad thing. I also wanted to convey the perspective from legal services practitioners. We've held monthly calls with legal services practitioners across the state of Maryland during the pandemic at MCASA. These are attorneys who work with domestic violence and sexual assault survivors. And we've learned a lot about the benefits of remote hearings. And they're, as you imagine, less trauma, less physical challenges, easier because of childcare, transportation, and employment issues, which leads me to also say this is really, if anything, too modest. We should have availability of protection for survivors at libraries, at casinos, at Camden Yards, at any other public place. And I'd also respectfully suggest that we should perhaps even include peace orders as well as protective orders. So I ask that the committee seriously consider an expansion of the bill, if anything, but certainly MCASA supports House Bill 296 with the sponsor amendments.
Lori Ruth for 2 minutes, please.
Good afternoon, Mr. Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I'm coming to you from very beautiful, warm, and sunny California. That's just to make you all jealous. Thank you for having me.
Thank you. Your time has expired. All right.
The Women's Law Center has protective order projects in several courthouses in the state of Maryland, and we have some statewide projects as well. And I want to thank, one, your committee staff for helping me today with my technology issues. And second, I want to thank the advocates for this bill, Melanie Shapiro and Sarah Mickey, because, you know, we had very frank and good conversations about this. And I really wanted to come in wholeheartedly favorable because, like Ms. Lenig, I completely agree that allowing people to get protective orders in a safe manner, especially if they're some of our more seriously injured victims who are hospitalized because of the injury they received by their abuser, would be a great thing. But I can't. And I also agree with Ms. Jordan. And so I'm in this awkward position of finding that that this bill is both too limited and too expansive. And I'm not exactly sure what to do about it. I agree with Ms. Lenig that there is a problem with commissioners. I am very concerned about overburdening hospital staff who are already overburdened. I am concerned about the lack of connection to services that are vitally important and why our protective order projects are located in the courthouse. But at the same time, I was very compelled by Ms. Shapiro talking with her the other day that this is an access to justice issue. And while the courts have been able to find a way to do remote hearings on almost every other kind of hearing there is, throughout COVID, victims of domestic violence have had to go in person to the courthouses. And for some reason, this has stymied the courts in some way. But I also think that Ms. Lenig is right. It might be better in some way to start with just temporary protective orders when the courthouses are open. They already have the ability and have figured out how to do remote hearings, whereas there is no mechanism right now for commissioners. And then from there, we could work on more expansive access with kiosks or any of the number of other ways that Ms. Shapiro mentioned as well. So the Women's Law Center is favorable with amendments, but we really, really support the idea of making this easier, especially for some of our most vulnerable and injured survivors of domestic violence. Thank you very much.
Thank you very much. Are there any questions for this panel? All right. Seeing none, we thank you all very much for your testimony, and that'll conclude all the witnesses for this bill. That concludes the witnesses for House Bill 296. We thank everyone for testifying today. We're done at 2 o'clock. Committee, don't get used to it, and please drop your bills. Thank you. That concludes the hearings today for the House Judiciary Committee. We will be back tomorrow. Thank you very much.